Hello everyone, this is Dr.Syamala from the Department of MBA IB, Acharya Nagarjuna University. Coming to today's topic, we are going to study about the Indian Patents Act. So what is about Indian Patent Act? What are the restrictions? What are the regulations? What are the rules? All can be studied under this concept. So before going to know about the Indian Patent Acts, we'll know about the genesis or else the history of the Indian Patent Act. Okay, so initially Italy was the first country to introduce these patents. Okay, so through the Vatican Statute in the year 1474, this Patents Act came into force. Okay, so firstly, Italy is the country which used this Patent Act, okay, for the first time through Vatican Statute, okay, in the year 1474, stating that all new inventions that are put to use should be informed to the public. Okay, any new invention should be before the public, should be put before the public. So it is required to inform the public about that new invention. So that is about the Vatican Statute. Okay, means why? Because why to inform the public? Why to state that invention publicly? Means in order to get the legal protection for that invention. Okay, in order to, so that legal protection could be granted to them means the inventors of the product. Okay, and protect them against infringers, means any other person, if at all they want to copy that product or process, means okay, those are known as infringers. So in order to protect from those infringers, okay, or else in order to protect from infringement, so this Patent Acts came into existence. Means if we want to state what function do these patents do, means they will protect the inventor from their invention. Why? Because not to any other person cannot infringe their patents. Okay, so basically what does patents means? Patent is a document. Okay, it is a document issued by the government of that particular country to the inventor, okay, for his or her invention, protecting the rights of that inventor. So it is a document issued by the government to the inventor for his or her invention, an exclusive right to make, use or sell an invention, okay, to the inventor. It is known as a patent. Means a publicly an official document will be granted by the government of that particular country. So they grant exclusive rights to that particular inventor for his or her invention to make or to use or to sell that invention. Okay, so that is known as a patent. So this patent may be either a process patent or a product patent. Okay, so if we see the Indian Patent Act was introduced in the year 1911. This is the first time initially when this Patent Act was introduced, means in the year 1911. So 1911 means at the time of the British government. Okay, so before our independence. And if we see after independence, in the year 1970, by the Indian government, Indian Patent Act was passed. Okay, so after 1970, in the year 1995, India joined WTO and TRIPS. TRIPS is nothing but the trade related intellectual property rights. Okay, why it is there? WTO is World Trade Organizations. Means all the trade related aspects can be protected there. Okay, the countries who are in those WTO or else the TRIPS, they will be protected. They will be protected from these IPR, intellectual property rights. Why intellectual property rights? Means patent is one of the part of the intellectual property rights. Okay, so the inventions or else anything will be protected from these treaties. Okay, why? Because we are the member of those WTO or else the TRIPS. Okay, so our inventions or else our trade related aspects can be protected there, safeguarded there. Okay, so in this year India joined in WTO and also TRIPS. TRIPS is nothing but the trade related intellectual property rights, where it protects the rights of the inventors. Right, now if we see, patents are basically monopolistic rights. Okay, monopolistic rights means it is nothing but an exclusive rights were given to the inventor. Means no other person has right to sell, right to use, right to manufacture that invented product. Okay, so that is an exclusive right given for that particular inventor. Okay, so therefore we can say that the inventor will enjoy the monopolistic rights, because he only can sell, he only can own, he only can manufacture, he only can give license. Okay, so he enjoys fullest monopolistic rights. So we can say that patents are basically monopolistic rights granted by the government of that country. Okay, means for what? The owner of the invention in any field to make, use, manufacture and market the invention. Okay, provided. Okay, provided means anything can be done by any person. Any person can give given patents by the government, provided the invention satisfy, it should satisfy, that particular invention should satisfy certain conditions stipulated in the law, certain conditions according to the patent law of that particular country. Then only patents will be issued to the inventor, and such rights are granted for a limited period of time, which is nothing but a limited period of time for a patent is 20 years. Okay, so we have different three types of patents, like a utility patent, plant patent, design patent. Okay, so for utility patent 20 years will be given, for plant patent 15 years will be given, and for design patent 10 years will be granted. So after that what happens? Means after that again these inventors, they will go for renewal of their patents. Okay, so invention, patents are the owner of the invention in any field have the right to make, use, manufacture and market the invention. Market is nothing but they will give license to the other persons to use their product. Okay, so provided the invention should satisfy the conditions according to the law, according to the stipulated law. Then patentability. Okay, so whenever the patents are granted, that person gets patentability. So patentability means patent is granted to the owner of the patent when he or his invention satisfies the conditions for patentability. In order to give patent, okay, so what are those conditions? Means first and foremost condition is novelty, inventive steps are non-obvious, and third one is industrial application. So these three are the most important requirements to get a patent. So what does novelty means? So novelty means the subject matter of patent should be new. So that is known as the novelty. Okay, so newness should be there. Okay, already existed aspects should not be taken into consideration here. Okay, to get a patent, the subject matter that we have represented there, okay, it should be novel. Which is nothing but, novelty is nothing but the newness. Okay, so it means that, for example, um, uh, novelty is based on a simple fact that any invention known, or else it is used, or else being used by others in any other country, or patented. Okay, or else patented means already that particular item is having patent rights in any other country, or for on any other person. Okay, or else it is described in a printed form in the home country or in foreign country. So in such cases it is considered as it is not having a novelty, newness, then it is not issued a patent. For that reason, no patent will not be issued to that particular person. Means novelty means subject matter should have a newness. Okay, already if it is existing, okay, in the country or else in the foreign country, or else already it is being used by any others in other country, or else it is in the form of that particular subject matter is in the form of printed form in the own country or in foreign country. Okay, in such cases patent will not be issued. Okay, so it is novelty. So if we see inventive steps are non-obvious. Okay, so inventive steps are non-obvious means uh, inventive steps means technical advance as compared to the existing knowledge should be there to grant a patent. So inventive steps, the method should be there. The method should be the inventive. Inventive steps should be involved in that particular invention. Means a technical advancement should be there. Okay, as compared to the existing knowledge. Already there is already there is a technical knowledge existing at particular time. Okay, so there should be any advancement in that subject matter. Okay, then only patent will be granted on the inventive steps, or else non-obvious. So non-obvious means mere extensions or modifications to any other subject. Okay, for example, I have I went for a patent application. Okay, just modifying some changes to a particular product. Okay, means a mere extensions have been made to that product, and some modifications has been made, and I went for patent application. Means in such case patents will not be granted. Why? Because it is non-obvious. Means just you are having some mere extensions to a particular product, some modifications has been done to that product, and you went for patent application. Means in such cases patent will not be obtained. So inventive steps should be there, non-obvious should be there. And third aspect is industrial application. Okay, so industrial application means it must be capable of being used in an industry. Then only whenever it is useful, only whenever it can be used by the industry people, whenever it creates commercial. Okay, for example, if we invented a product, means then we'll sell it. Okay, or else we'll give license for it, then we will obtain some amount on that particular product. Okay, so this should create an industrial application. Okay, so it must be capable of being used in an industry. A commercial benefit should be provided. Okay, so if we see next one, so these are the three conditions or else the requirements to get a patent. Without these, patent cannot be issued. Then object of grant of patent. So what is the objective of patent? Means the main objective of the grant of patent is to encourage scientific research. Okay, scientific research, new technology, industrial development and innovation. So this is the main reason for encouraging the patents, okay, granting the patents in order to encourage the scientific research, new technology, industrial development, innovation. All these leads to the public interest, okay. All these will enhance the living of public, okay. So therefore they will grant the patents, okay, and the main objective is to encourage all these things. So if we see what is a patent, definition of patent according to the Patent Act means section 2M states that a patent for invention granted under this act is known as a patent, okay. So patent law, so this is nothing but as I described in the above. What is that? Any document which is issued by the government to the inventor for his invention, okay, grants him exclusive rights to own, to sell, to use, or to manufacture that invention, okay. So patent law grants exclusively privilege to patent owner, exclusive rights to the patent owner, which is nothing but the monopolistic rights, okay, according to the section 48, okay. Then we'll see about section 3 and section 4. So section 3 and section 4, what does it says means they are related to non-patentable items, okay. So section 3 and section 4 deals about the non-patentable products or processes. So as I said before, patents can be product related and process related, okay. Patents are product related and process related. So process patents are those patents which are granted for a particular manufacturing process, okay. So for example, this is process, okay. Under patents, process and product, okay. Process patents and product patents. So under process patents, patents are granted for a particular manufacturing process, okay. And for the product means for the article itself, patent will be granted, okay. So under patents we can see the process patents and product patents. So here what are those non-patentable aspects we will see now, okay. So section 3 and section 4 deals with the non-patentable patents. So like scientific discoveries, living beings, plant, animal, microorganisms, new form of known substances, additive combinations, traditional knowledge, business methods, mathematical methods, atomic energy according to section 4. Atomic energy is related to only section 4, okay. So all these are non-patentable, even though if you have find anything means, okay, according to all these aspects, patents will not be issued by the government, okay. So these are non-patentable aspects. So for example, if we see what are non-patentable means, all this comes like all these may lead to frivolous, which may be which may hinder the public interest, frivolous, illegal, or else admixtures. Admixture is nothing but, for example, if we have a additive combination is that only admixture. So admixture means if a product A is there and a product B is there, okay. So by if we combine A and B and invent C, okay, and if we go that I need patent rights on this means patents will not be obtained, okay. So additive combination, admixture, for this patents will not be obtained. Already for known substance it will not obtain, okay. For microorganisms, animals, plants, because already plant will be there, okay. So we cannot give patents on those, only on the distinctive character only patents will be issued on this plant, okay, but not finding out for a plant we don't get a patent right, okay. So likewise for business methods, for traditional knowledge means from ages onwards in some countries, okay, they may follow or else they may know the knowledge on that. So for that also uh, patents will not be issued. So all those comes under the non-patent items. Especially for this atomic energy, it is not patentable, okay. So patent performs two commercial functions, okay. So what are those two commercial functions means? One is patent creates a market barrier, okay, and the other one is the royalty. So what does market barrier means? So we know that according to the patent acts, inventor gets exclusive rights, okay. According to section 48, any inventor can get exclusive rights through patent act, means he only owns that invention, he only sells that invention, he only uses, he only manufactures that patent or else that invention. So it creates a barrier to other competitor. If we are in a business world, for example, okay, so other competitors for our product, okay, it creates a barrier to them, means they cannot make our invention, they cannot use our invention, they cannot manufacture our invention. So in that way it creates a market barrier, okay. And the other one is it ensures royalty. So royalty is nothing but the benefit that we get from the other party by uh, giving permission to other party to use our invention. That means in the form of licensing, just we are giving license to the third party to use our invention. For that, for giving license, we will benefit royalty from the third party. We will not transfer the ownership right in this licensing case, just we will give a license to use our invention to third party in consideration with this royalty, in consideration of some payment, okay. So these are the two commercial functions under patents. Next, what are the types of patents? Okay, utility patent, plant patent, and design patent. Okay, so these are the three types of patents. So what does utility patent means? So utility patent means inventions that belong to category of machines, processes, compositions, articles of manufacture, or new uses of any of these are granted utility patents, okay, for machines, process, compositions, articles, all this. So these are known as utility patents, means um, the ideas are not patentable but the processes are patentable, okay. So process means the idea is not patentable but the method that we use for that product, okay, for that only patent will be available. So that is known as utility patent, not for idea, only for the method, okay. So likewise for machines also, okay. And a machine is a device having parts that perform or assist in performing any type of work. So apart from this, any device transmitting or transforming entry may also be called as a machine. So for this also patents will be obtained. For compositions, okay. So what does compositions means? Combination of any chemical or other materials is known as a composition of matter. So the natural substances are not granted patents but their combinations can be protected. So compositions means the combinations of any chemicals, okay, combinations of any chemicals or other materials. It is known as a composition. So for composition, utility patents are granted, but not the natural substances are not granted. Okay. Now, articles of manufacture. So article of manufacture is also principal category of this patent. So an article of manufacture refers to an individual object that does not comprise of any movable parts. Okay. So for that, utility patent is granted. For example, a pencil, chair. Okay. So that is an article. Then if we see plant patent, so plant patent means they are also patented. Okay. But provided they are either discovered or else created by an individual. Already plants will be there. Okay. So the person, he invents the distinctive nature in that plant. Okay. So for example, that distinctive nature may help to cure the cancer. Okay. So for that invention, patent will be given, plant patent will be given to that particular person. So design patent. So design patent means any new original and ornamental design invented for an article of manufacture is patentable. Okay. Now, persons entitled to apply for patents. Okay, according to section 6. So who are the persons to apply for patents? Means who can apply for patents means a valid and first creator of invention. So that person can go for patents. That person can apply for patents. And another one is assignee. Okay, who is this assignee? Means assignee is any other person, or else the person on behalf of the inventor, on behalf of this first creator, will be entitled to apply for the patents. And a legitimate agent of any deceased individual who is preceding his demise. Legitimate is nothing but the legal agent of any deceased individual. If that individual is not well, or else he is going to die, or else the demise of that individual creator or that invention person, inventor, so he will give a legal agent. Okay. So that legitimate agent also can go for, or else entitled to apply for patents. And here if we see note, either alone or mutually with some other individual, patents can be applied if at all a product, okay, if at all this product is invented by two persons mutually, jointly, then both of them can go for to apply for patents. Okay. So who are the persons entitled to apply for patents? Means the first creator of the person, the idea, who got the first idea, the valid person and the first creator of the invention, or else the person who works on behalf of the inventor, who is nothing but assignee, and the legal agent. Okay. All these persons can go for patent application. Okay. Now, all this is about the introduction about the patents. Now, if we see the procedure of the patent application. Okay. So now we have to go for the application in PTO office. Okay. We have to go and register our patent. So in order to register our patents, we have to apply for that. So what is the procedure for application, and how we can get the grant for a patent? Okay. So what all the procedure will be seen here. So first one is filing. Okay. So what does filing means? Patent application is to be filed in Indian Patent Office. First and foremost thing is where we should file, means in Indian Patent Office. We have to go there and we have to file our application. So then it can be provisional application or complete application. So in this application there are two aspects. One is provisional application, other one is complete application. Okay. So provisional application, complete application. Provisional application is just details of the inventor, name of the inventor, name of the invention, okay, or else the design of the invention. All these aspects will be given in the provisional application, okay. But coming to complete application, the full details regarding the invention will be given in this complete application. The full specifications regarding from the title to till the person who will be the legitimate agent, or else who will be the assignee, all the things regarding the design of the thing, the design of the invention, or else the claims. There will be different type of claims like dependent claim, independent claim, regarding the claims, or else regarding the drawing of the models, regarding the best mode used in that, okay. So different specifications will be there in the complete specification, okay. So provisional means under provisional, just it will mention about the inventor name, invention, design, and all that thing. But coming to complete application, the full details of the invention will be there, like about the application data sheet, transmittal letters, mailing, uh, everything, examinations, regarding everything will be there in the complete application, okay. So in case of a provisional application, the complete application must be filed within 12 months from filing date. So there will be a date for this complete application, okay. Whenever we go for provisional application, okay, within 12 months of that provisional application, we have to submit this complete application also. It also must be filed within 12 months, okay. Within the 12 months of provisional application, submission of provisional application, we have to submit this complete application within 12 months. If not submitted this complete application means, okay, any other person may apply for the same patent, okay. Why? Because we have not submitted complete application within the 12 months, so there it is cancelled our patent, okay. So whenever complete application is submitted within the 12 months of submission of this provisional application only, our patent rights will be safeguarded, okay. So this is the difference between the provisional application and complete application. Provisional application is in order to safeguard our invention, in order to safeguard our right. Provisional application will be submitted in the PTO office, Indian Patent Office, okay. So if we see, next step is publication, okay. Under publication, according to section 11A, what does publication means? So Indian Patent Office is required to publish the patent application, okay. The patent office has to submit the patent application after 18 months, okay. So from the date of publication in the website, in their office, okay, they will publish our patent, okay. So that is known as the publication. The journal will be published. In the journal, our patent will be published. So from the date of publication, the inventor started enjoying the provisional rights and privileges. From the date of publication, whenever our patent is on publication, okay, from that time onwards, we will have the rights, okay, provisional rights, and also the privileges will be there. The what privileges means? No other person has the right to have this rights on our patents, okay. So the publication includes particulars of date of application, application number, name, address of applicant, along with the abstract. Abstract is nothing but the summary of our patent, okay. So all these will be there in the publication. And the application of patent are not open for public inspection before publication. So before publication no one is able to see our patent, but after publication it is in public. Everyone can inspect our patent. If at all there are any objections regarding that publication, they can go for objection on our patent. Okay, so that is known as publication. That so through publication public may see our patent. Okay, if at all by seeing our patent any person can object on our patent also. Okay, on there are certain grounds for objection also. Okay, so depending upon those grounds, if at all our patent is not up to date, up to mark, then opponent can go for opposition on our patent. Okay, then pre-grant opposition. So this applies here whenever we went for publication. Okay, our patent is published, then our answer and so ground. Okay, for example, we have obtained wrongly the patent, or else already the patent is existed in any other country. On that particular ground, any other applicant for say B, the B person may approach. Okay, may approach the office, PTO office, sending a notice that for objection. Okay, for objecting not to give patent to A. Okay, so this is known as pre-grant opposition. Pre-grant means just our patent is published only, but not granted. We didn't get any patent certificate. Okay, just in PTO office, in their website or else in their journal, they have published about our application, patent application, so and so inventor, so and so invention, so and so design, like that. Only our patent application will be published in that. Okay, but not yet granted. Till now we have not granted the patent, just we went for publication only. Okay, so in that case, if any person may in writing, okay, to the controller raise opposition against the grant of patent, as I said here, B on different grounds, like wrongly obtained. So on that ground he may approach controller in a written document. Okay, he can go for opposition on A to not to grant patent. Okay, so this is known as pre-grant opposition according to section 25 subsection 1. Okay, so pre-grant opposition, some other person is opposing our patent for not granting patent to us. Okay, and next one is request for examination. If at all there is no pre-grant opposition after publication, if there is no pre-grant opposition, no opposition is there, means then we can go for request for examination. So request for examination is nothing but they have to check according to section 3 and 4 our patent is there or not. Means the examiner has to see non-patentable items are there, or else our patent is frivolous, dangerous to public interest, or else our patent is illegal, our patent is in atomic energy, consist of atomic energy, means according to section 4 atomic energy is non-patentable. So likewise any non-patentable items are there. Okay, so all these things has to be examined by the examiner. So whenever we went for request for examination, so there examiner will examine about our patent. Then after request for examination, first examination report will be given, FER, first examination report according to section 12. So after examination means the report will be given. So what will be in the report means the examiner either may object the patent, or else he may continue requirement. According to the requirement, he may continue, he may give the report. Okay, so objection means on different grounds he may object. Okay, so if at all they are not according to the conditions, requirements like novelty, non-obviousness, inventive steps, okay, industrial applicability, on all these cases, if at all the patentee, the person who went for application, he doesn't satisfies all these requirements, means the examiner may object. Okay, likewise application or complete specification should be amended in order to meet the objections. Okay, so if at all in first examination report objections are there, and those objections can be cleared by amending means. Okay, so within a period of 12 months that person may go for amendment. Okay, then can clear the objections. Okay, if all objections are not compiled within the period of 12 months, if at all those objections are not amended within the period of this 12 months by the applicant means, then the application shall be deemed to have been abandoned. Okay, so it has been rejected. Then after FER report, grant for patent finally. Okay, section 43, according to section 43, grant of patent will be there. So when all requirements are met, the patent will be granted after 6 months from the date of publication. Okay, after publication, okay, from that date, after 6 months, patent will be granted. So the letter of patent will be issued. So entry is made in register of patents. Our name will be entered in the patents register and is notified in the PTO office journal. Okay, so this is the granting of patent. So if at all after grant of patent, okay, if at all any third person, any person went for opposition, means that is known as post grant opposition. Okay, so see, in pre-grant position, even till our patent is not granted but went for only just publish. Okay, so in that case, if any person went for opposition, means it is considered as pre-grant opposition. But we have granted patent. Okay, but after grant of patent, any third party, any person went for opposition on our patent, means that is considered as post grant opposition. Okay, so at any time after the grant of patent but before the expiry of period of 1 year from the date of publication, any person interested may give notice of opposition to the controller in the prescribed manner on any prescribed grounds stipulated under the law, according to the act, according to the conditions, according to the requirements, according to the law. He can give notice of opposition to the controller. Okay, that is known as post grant opposition. So for post grant opposition, there are different grounds like wrong obtainability, prior date, or else geographical specifications. So different aspects, on different aspects, opposition can be made after post grant opposition. Okay, so after that, withdrawal of patent application, if at all these have been completed. Okay, meanwhile, if the patent he want to withdraw the application, okay, then how to do it? The application of patent can be withdrawn at least 3 months before the first publication. Okay, see here, publication, this is the first publication. Okay, so at this time, 3 months before of the first publication, he can withdraw. Okay, he can withdraw the patent who want to apply for the patent before the first publication. At least 3 months he has to withdraw. The application can also be withdrawn at any time before the grant of the patent. So till now, after publishing also, okay, the patent also granted, grant of patent is also have done, even though at that time also he can withdraw. Okay, application can also be withdrawn at any time before the grant of patent, because after granting of the patent we can't do anything. So before grant of patent, at any time the application can be withdrawn. Okay, so the application withdrawn after the date of publication cannot be refiled, as it is already laid upon for public inspection. Okay, so whenever it is went for date of after the date of publication, okay, then refiling cannot be made. Okay, so withdrawal can be made at least 3 months before the first publication, means it is in the process of publication. At that time withdrawal can be possible. So however, application withdrawn before publication can be refiled, provided it is not open to public otherwise. Okay, so anytime it can be withdrawn. Okay, application can be withdrawn and also can be refiled if at all necessary, but when provided means it is not opened to public till it is not before public. Okay, we can withdraw at any time. So publication, if there is no withdrawal, okay, then directly. So if we see, if at all there is no pre-grant opposition, post-grant opposition, no withdrawal, anything, means just directly after the first examination report, grant of patent will be given. Okay, so that is through after grant of patent we will directly go for publication, if at all these aspects are not there. Okay, so publication means what else is there? Mentions it the patent office mentions about the product, either it is a product based grant or process grant on, and the person name, whoever invented, the inventor name, and the date of grant of the patent, all will be published there. All the documents regarding the invention will be available in the public domain. Okay, so this is just a flow chart regarding the procedure of this application. Okay, for patent application. So complete application, provisional application, complete application. So complete application should be made within 12 months of this provisional application. Afterwards publication will go for publication. Okay, so publication, after publication, if there are any opposition, pre-grant opposition will be there, means till now we have not granted any patent, so that is known as pre-grant opposition. If at all there are any oppositions, so the applicant and opponent, they can, both of them can go for the controller, and there will be a board of appellate, and there they can go for hearing of their cases. Okay, and after that if at all there is no pre-grant of opposition, means after publication they can go for request for examination, means regarding their invention, if at all there are any flaws, if at all there is any frivolous activities, if at all there are any things illegal, so all these can be examined by the examiner in this request for examination. Then FER report will be given, and after that granting of patent will be done. Okay, so after granting of patent will be done, if at all there is no post grant opposition, directly publication will be made. Publication is nothing but giving full details, full documents of our invention, all will be kept in the public domain. So this is about the provisional procedure of the patent. Okay, then if we see types of applications, as I said before, here we have provisional application, complete application. Okay, so types of applications are these: provisional, complete, convention. So I have explained already provisional application, complete application. Coming to conventional application, what does conventional application means? When an inventor or an applicant files patent application in Indian Patent Office claiming for priority date based on a similar application. Okay, filed in convention countries, such applications are convention application. So as I said before, our countries will be, our country is the member of WTO and also TRIPS, okay, trade related intellectual property rights. So being member in these countries means, so we are treated as a convention country, okay, means for example, A country, B country, okay, two countries, sorry, a person A and person B is there, okay. So uh, we all know that provisional, when will be provisional application will be submitted for the patent office, okay. So A submitted in the year of 1st January, okay, 1/1/2023, okay. So B applied in patent office 1, okay, 1/4/2023, okay. So A applied provisional application in the date of 1/1/23. B applied provisional application in the year of 1/4/2023. So there is 3 months gap. So provisional, so the priority date, see here, depending upon priority date, okay, they will see the applications, and depending upon priority date they will give the patent, they will assign the patents, okay. So here priority date means, so if we see here in this case, provisional applications submitted on a patent by both of them, A and B, okay, but the month is, here is January and here is April. So who else went for patent office first means A. So who will give the patent means first given to the A only, not for B, because the priority date is for A only here, okay. So if at all, for example, if we see in complete application, okay, provisional, not for provisional application, complete application, if we go for complete application, so same if we see A and B, okay. So for A and for B, okay. So A 1/12, okay, 2022, okay, for complete application. A went for complete application. So if we see B went for 1/6/2022, okay. So B went for complete specification on this day, and on this day A went for complete specification, okay. But A after completion of here provisional application, okay, within 12 months he doesn't go for complete application, okay. So within 12 months means, for example, he went for provisional application in the year 1/12/20, for example, okay, but here he went for complete application in the year 2022. So the gap is more than 12 months. So therefore complete application for this patent office will not give the application for him, okay. So prior date will not be given for this A, prior date will be given for B only, okay. Why? Because within the stipulated time, within the application of a provisional application of 12 months, he went for complete application. Then B will get priority date. So priority date depends upon the provisional application and convention complete application. Depending upon that, priority date will be decided. Okay, so convention application is depending upon the convention countries who are in this WTO and TRIPS. Okay, so those those countries, they will protect the rights of the inventor. Okay, so it also depends upon the priority date. Whoever produce first provisional application and complete application, so depending upon the priority date, it will be given. Okay, so this is about the convention application. Internationally, okay, in international level, our patent rights will be protected depending upon the priority date, that is known as the convention application. So this is about the procedure regarding the application in Patents Act. Okay.